So let's talk about beneficiary designations versus having a last will and testament in Florida. They work hand in hand to control the administration of your estate when you pass away. But the will is not going to replace beneficiary designations on your assets. So what does this mean? In Florida, certain assets will pass by transfer on death or pay on death beneficiary designations. That is contract law. It is not estate planning law. So what that means is if you have a life insurance policy, a 401k, an IRA, that when you set up that account, they're going to ask you to designate beneficiaries, and you're going to list the people that are going to receive the payout from that account when you pass away. You have to maintain those beneficiary designations. If somebody that you've listed has passed away before you, you may want to update those beneficiary designations. Make sure that there's always somebody listed who can inherit that account. But if you don't put beneficiaries on those accounts and you pass away with a will, the will is going to control the probate. The will is not going to name a beneficiary. So those assets are going to go through probate. So if your will says everything to John and Sue in equal shares, then your IRA, your 401k, those pay on death beneficiary accounts are going to have to be probated before they can become part of your estate and then be passed according to your will designation to those two named beneficiaries. The easiest way for you to maintain control of the passing of your assets on those accounts after you pass away and to ensure that they are inherited by the individuals that you want to inherit them is to put beneficiaries on those accounts as soon as you create them and to ensure that you are maintaining them throughout your lifetime. This gives you the control of who inherits your assets and keeps them out of the costly and time-consuming probate process. Thanks for watching. I'm Eve with Lumsden Law.